This is my second recording on the decision of the Supreme Court in the Triple Point case. The first recording related to the liquidated damages provision, which I argued. The second one deals with the court's construction of Clause 12.3. Clause 12.3 was a limitation of liability clause, which had an exception to the limitation at the end. And it's the scope of that exception that the court considered. There was a further point about whether liquidated damages were carved out of the exception. Point was a genuinely one-off one, and I shall not be looking at that. I'll simply confine myself to a few words about 12.3. 12.3 started with the contractor being liable, Triple Point being liable to PTT for any damage suffered by PTT as a consequence of Triple Point's breach of contract. The total liability of Triple Point to PTT was limited by a particular formula. There was then in the fourth sentence a carve-out, and this said, this limitation of liability shall not apply to Triple Point's liability resulting from fraud, negligence, gross negligence, or willful misconduct of Triple Point or any of its officers, employees, or agents. The issue before the Supreme Court was whether the word negligence referred to a breach of contractual duty of care, as PTT contended, or a breach of a duty of care in tort, which did not give rise to a concurrent liability for breach of contract, as Triple Point argued, and as the judge and the Court of Appeal held. On this topic, the Supreme Court was split 3-2. Lady Arden, Lord Burroughs and Lord Leggett decided it included to a contractual duty of care, and Lord Sales and Lord Hodge thought it did not. Lord Sales observed that he was following the decision of four experienced judges. Difficult to fault the experience of the four of them, Lewison, Floyd, LJJ and Sir Rupert Jackson and Mrs. Justice Jefford. Those who disagree with the Supreme Court's decision may be looking forward, as we all are, to the next edition of Lewison on the construction of contracts. Even though Lady Arden did not mention this point in her oral judgment when delivering the judgment of the Supreme Court, because it was a question of construction, there's a great deal, particularly in Lord Leggett's speech, on the correct approach to clauses of this sort. The majority was clear that the word negligence was sufficiently clear to encompass a contractual duty. It reached that view on the basis that negligence was included. It was unimpressed by the suggestions there were other categories of breach that would give the word some meaning. Lord Leggett at paragraphs 106 to 113 looked at the approach to limitation clauses. He said at paragraph 106, clear words are necessary because and I'll read the exact words. Clear words are necessary before the court will hold that a contract has taken away valuable rights or remedies which one of the parties to would have had at common law or pursuant to statute. He then in the next 4 or 5 paragraphs goes through the law, and those interested in this area will find this a helpful end. And he gets to a fascinating conclusion at paragraph 111. And what he says is, to the extent that the process has not been completed already, old and outmoded formulas such as the three-limb test in Canada Steamship and the contra proferentem rule are steadily losing their last vestiges of independent authority and being subsumed within the wider Gilbert-Ash principle. As Andrew Burroughs QC, also a subscriber to this judgment, said in Federal Republic of Nigeria, applying the modern approach, the force of what was the contra proferentem rule is embraced by recognizing that a party is unlikely to have agreed to give up a valuable right that it would otherwise have had without clear words. And as Moerbeek, LJ, put it in Stotsnier, the more valuable the right, the clearer the language will need to be. So, for example, clear words will generally be needed before a court will conclude that the agreement excludes a party's liability for its own negligence. This is to be balanced with what Lord Sales said at paragraph 143. So when he says, approaches the words in this clause, so what was the point of adding negligence to the list of forms of conduct to which the limitation of liability was not to apply? For the reasons I've given, the list as a whole is intended to refer to liability in contract and liability in tort. However, in case of negligence, to avoid incompatibility with the fundamental object of the second and third sentences of Article 12.3, those are the release word paragraphs, and to avoid incoherence and textual redundancy in the fourth sentence, that specific that term can only sensibly refer to liability in tort. It therefore must be taken to refer to the freestanding tort of negligence, which, like the other terms in the list, is something apart from an ordinary incident of commercial relations under the contract. And he then approbated Sir Rupert Jackson's explanation of the point at paragraph 119 of the judgment of the Court of Appeal. What, therefore, is there to learn from this part of the decision? First, you can persuade 6 judges out of 9 and still lose. Second, the approach of the Supreme Court to this sort of this exclusion clause appears more technical than the more generous approach that might be thought to be adopted in relation to liquidated damages. Third, there is a tension between the technical approach and the various presumptions of construction and a more general attempt to identify what the courts what the parties in fact meant when they made their contract. This, like the decision on liquidated damages, is capable of having far-reaching consequences to the law of contract. Again, as with the first one, I look forward to discussing these issues and every other issue with all my professional friends as time goes on. Thank you very much indeed for listening.